We are the CAT8, also known as the Community Assistance Team 8.
Is a group of Jain individuals and professionals
who are assisting the community at large
during the COVID-19 crisis.
CAT8 began just before the COVID-19 crisis,
when it held a can challenge,
where children created iconic monuments
using cans of food,
raised some 3 tons of canned foods,
enough supply for 4 months,
for the Watford Food Bank,
run by the Trussell Trust.
During the COVID-19 crisis,
CAT8 is helping the elderly, the vulnerable,
those in isolation and key workers.
With meals, essential shopping,
help with medicine collection,
and someone to talk to
whilst coping with isolation.
CAT8 has lined up
a series of webinars.
In addition, we have created a helpline
for individuals and businesses
that need guidance
on the various government schemes.
And the topics of the webinars.
CAT8 is working with
or supporting various organizations,
including Go Dharmic,
Sevate,
Navnath,
SCVP,
One Jain,
the Trussell Trust,
and working with many volunteers.
CAT8 is the newest network fiber,
connecting the community.
Next slide, thank you. We are very kindly supported by a number of businesses to enable CAT8 to carry out our work. So we'd like to thank them all. Okay, next slide, please. Our speakers today are Vinay, who is the managing partner at Garner and Hancock Solicitors, and Daniel Flynn, who is partner at Garner and Hancock Solicitors. If I may introduce Vinay, studied at UCL and Royal Holloway, University of London. He has been a solicitor for over 20 years and is now the managing partner at Garner and Hancock Solicitors. He specializes in dispute resolution and litigation. He's a trustee and legal counsel for various charities and a director of the Avanti Schools Trust. So welcome, Vinay. And then the other speaker is Daniel Flynn, who trained as a barrister before cross-qualifying as a solicitor advocate in 2016. He is now a partner and head of dispute resolution at Garner and Hancock Solicitors, with a broad dispute resolution practice covering property disputes, landlord and tenant, contentious trusts and estates, matrimonial finance. His recent cases include a reported case on claims by an unmarried long-term partner against an estate, a matrimonial finance case concerning the treatment of companies overseas, a 3-way litigation over the ownership and management of a large portfolio of investment properties in London, and a dispute over a trust of property between siblings going back over 30 years. Outside the courtroom, Daniel can usually be found hiking or cycling up a hill somewhere along in the UK, I presume. So welcome, Daniel. Over to you, Vinay. Thank you very much.
So good evening, everybody, and thank you very much for coming on board this evening. So we now enter into the 3rd month of this semi-lockdown. The economy appears to have shrunk by 20% and the property market is yet truly to kick in. We expect mortgage repossessions and evictions to be on the rise as we proceed through the year. There may be opportunities for some, but others, particularly landlords, this could mean defaulting tenants, delinquent payers, and those who are genuinely in financial difficulties. Just to give you some statistics, in 2019, there were about 100,000 repossession orders, and about 30,000 were granted and actually went through to an eviction. But we believe actually this will rise between 40 and 50%. And I think this is because of what's been happening with regard to the crisis and the possible slow recovery. For those of you who've gone through repossession action and those who've luckily avoided this with your tenants, there are two distinct paths for a landlord could take to evict a tenant. First, there's the Section 21 proceedings, which is the mandatory 2 months notice, and then you are guaranteed a possession order. That is, if your paperwork is spot on. And the really district judges look for everything technically to be correct, because you are going to be given that possession order if it's all correct. The government have decided perhaps abolishing this, and there was a bill in Parliament which is yet to go through the whole process of Parliament to get to law, where you would have needed a reason to evict your tenant. So this is a big step away from the mandatory right that you would have had, where you simply issue your notice of Section 21 and you can get rid of your tenant. Now, of course, potentially with this law, which may appear, you're stuck with your tenant unless something happens. And the law appears to be on the back burner, but we suspect the government will reignite their interest in this law once this crisis is over. So look out for this. A small proportion of repossession cases under some Section 8. Out with Section 21, Section 8. Section 8 is where you seek rental arrears. So a lot of people getting themselves into rental arrears. What is the landlord's choice? This may appear quite a neat solution where you can seek possession as well as your rental arrears. But unfortunately, although it's only a 2-week notice rather than 2-month notice, landlords get stuck in court, bogged down with counterclaim. So once you have a claim for rent, you can actually issue, the tenant could issue a spurious counterclaim. They go to solicitors, and solicitors will advise the tenants to stick in a counterclaim. This will give them more leverage and effectively to try and negotiate out of a way to reduce that rental arrears. And I think this is where it's going. I really truly believe that the Section 21 and Section 8 are there, but they are difficult. Section 21 on the technical grounds, Section 8 because there is potential issues of a counterclaim and being dragged through the courts. So now I want to ask you a question. If I can flip over to the next slide, please. I'd like to ask a question for everybody, and please do use the chat. I'd like to ask a question. Which is the most important document when trying to recover possession of your property? Is it an EPC certificate? Is it a gas certificate? Or is it a tenancy agreement? Or perhaps is it an electricity certificate? So certainly have a quick think about this. It's not quite a trick question, but it really does bring home exactly the sort of things that people should be concentrating on. I'm afraid myself and Daniel, my colleague, notoriously see documents which come to us, usually in a Tesco's paper bag, to say, here are my tenancy agreements, here's everything, please sort it out. And we have to effectively make sure that all those paperwork are correct before we lodge them at court. So I'll give you a few more moments, but I'm going to hand it over now to my colleague, Daniel, who's going to give you the answer. And I hope that it'll be a bit of a revelation and an eye-opener. So over to you, Daniel.
Hi, this is not strictly to do with landlords' rights during lockdown, but this is something that we see so often at the moment that people are surprised by. It's a law that was sort of snuck out between 2015 and 2018. Probably one of the most crucial document that I've seen problems with when people are trying to recover their possession of their rental properties is the gas safety certificate. Almost sort of under the radar, the fact that you can't issue a Section 21 notice unless a gas safety certificate was provided to the tenant at the beginning of their occupation of the property or before the beginning of their occupation of the property, if there's gas in the property, which there obviously often is, that means that unless the tenant is then in breach of their tenancy, such that you can get possession under Section 8 of the Housing Act, they basically have a tenancy for as long as they feel they want it. Now that's being tested in the court. We're getting the judgment in the case which I've mentioned there for the more law geeky amongst you, Trecarrell House Limited in Rounsfield. The Court of Appeal is considering whether it makes any sense that people should have these effective tenancies for secure tenancies on the basis of a failure to have the gas safety certificate provided at the beginning of occupation. But at the moment, the position is that they do. Not really to do with landlord rights during lockdown. And there are a lot of issues about possession proceedings during lockdown. So without further ado, obviously at the beginning of lockdown, and the beginning of more generally of the health emergency that we're currently all trying to work through, there was a lot of concern about what might happen to people's housing. The expectation was that people should stay in their own homes, which is difficult when you're kind of in a transition between homes. But at the same time, housing transactions still have to go on. People often might have exchanged contracts already or might need to sell a house for some reason and need to get vacant possession. They might be having problems with their tenants. So how did the government square the circle? Well, the starting point is that you still, as ever, need a court order to end a tenancy. So since 1977 and before that at common law, it's been illegal under the Protection from Eviction Act to evict people without a court order. And it's obviously a person's home is an important right, and their right to remain in that home unbothered is an important right. So we still need to go through the court process, and nothing has changed the fundamental position under either Section 21 of the Housing Act or Section 8 of the Housing Act or the other aspects of the housing law that allow you to end tenancies and occupations. It mostly remains unchanged, and the changes that I'll come to are functional rather than the meat of the issue. So the first thing to note is that you can still start proceedings for an eviction. It is still possible to serve a notice requiring a tenant to give up possession of the property. It is still possible to start a court case. It's unlikely that anything's going to happen with either of those in the sort of short term. And there are two fundamental changes which the government has made to how these sets of proceedings are being managed. So the first of those is with regards to the notices that must be given. Now, for various different, Vinay's mentioned that for recovering possession of a property under Section 21 of the Housing Act, you have to give 2 months' notice. In some cases, slightly more, depending on the circumstances of the tenancy. But for a tenancy where they pay their rent monthly, it must be 2 months' notice. From between 26th of March and 2020 and 30th of September 2020. That has been extended to 3 months' notice. So every single notice given must give the tenant 3 months. And that applies not just to Section 21 notices, where the difference between 3 months and 2 months is not that grand, but to all notices requiring possession of property. So normally under Section 8, where there's arrears of rent or breaches of the tenancy, you're only obliged to give the tenant 2 weeks' notice before you start proceedings. In the current lockdown rules, where it's a notice served between those two dates, 26th of March and 30th of September, that is extended from 2 weeks to 3 months. So as you can see, that's already going to slow that process down quite substantially. As I've said, notices can still be served, proceedings can still be started, but the next thing has come not so much from government, but from the court service itself. So a rule was brought in March, which was awkward because I had a hearing on this day and nobody really knew what was going to happen. A 90-day pause was brought in for every case that had anything to do with possession from 27th of March to the 26th of June. So that was brought in. So any case that was already ongoing, proceedings were simply paused. Any case that had a hearing between those two dates in the court, that hearing was cancelled and postponed into the future after the 26th of June. Any cases where directions were ongoing, it's less clear what was happening. I think directions are expected to continue but the court hearings are not going ahead. So it introduced quite a long pause in the process of anything that's going through the courts. That just earlier this week was extended, so now it's the pause is until 23rd of August 2020. So the courts are not going to be doing anything, any work progressing any cases seeking possession of property, except for trespassers, until 23rd of August 2020. So I should say that's it applies to all normal cases with tenants and licensees and lodgers, and any problems where you're ending tenancy agreements and ending any normal residential arrangement. The one exception is where there are trespassers who are occupying a property. Those cases are not paused, although how they're going to get into court at the moment remains to be seen. The courts are open at the moment, but extremely limited capacity. So there's having very, very few in-person hearings, and they're having very, very few remote hearings using either video conferencing software. The court uses, it has its own bespoke video conferencing software, which doesn't work. So the capacity for work in the courts at the moment has been severely reduced, as well as by all of the normal things that everyone's facing during this pandemic. So staffing problems, problems of capacity, and making sure that we're able to socially distance in the buildings. And the reason that I mention that is partially because it's the bane of my life at the moment, and partially because people should bear in mind that when things open back up, it's unlikely to go back to normal. The courts were always a bit slow and always a bit under-resourced. When we come back from this coronavirus, this backlog is going to be extreme, and it's going to lead to some pretty extreme delays in recovering possession of property. So the other thing that people have been asking about in this interim period is if we don't want to go quite as far as recovering possession of the property, and or if we do want to go that far, but unfortunately it's not really going to be possible or practical at the moment, what kind of interim measures are there that are available? Now, a lot of people, for example, have been talking about rent reductions, and certainly in the context of commercial property, that's something where landlords and tenants have been having negotiations and trying to work things out. There is no law, no legal basis, no legislation or practice direction or guidance or anything about giving anyone a rent reduction. So any, beyond the fact, I think that the Minister for Housing said landlords and tenants should both act in good faith, which obviously would be lovely if that happened all the time. It's possible, of course, to discuss any pause on rent or any rent reduction or any deferral, and to come to an agreement with your tenant. And it might be worth thinking about a commercial angle on that, because I think the question is going to be what are your alternatives? If you have a tenant who is struggling to afford their rent, it's going to be difficult to get them out, and it's going to be difficult to find new tenants. So why not at least get some money off them? So going through the law on this, there is no obligation to offer a rent reduction or waiver or any change of the contract. The contract between the landlord and the tenant remains in place and unchanged. If you did want to offer something to help out a tenant, then it might be on the basis of a deferral. You could say to them, we propose that we will recover this rent from you in the future. So we will just allow a bit of a debt to accrue, and in due course, when things have calmed down a bit, you can pay that arrears, that debt down. Maybe the best thing to do in such circumstances would be to have that in a written agreement, and would be to say, I will reduce your rent. Let's both sign something confirming that your rent will be reduced for this period, but that you will still owe me that money. It will just be that I will defer recovering that money from you, and it will still be a debt, and it will still be something that you will have to pay back to me in due course. There will still be arrears of rent, and that's something that's important to remember, is that arrears of rent is one of the bases upon which you can recover possession of a property under Section 8 of the Housing Act. Arrears of rent will be accruing, even if there's an agreed deferral. You could say in that agreed deferral, if this goes on for X period after, it's difficult to forecast, isn't it, to say when this is all going to go back to normal, but you could put a period in there saying I am entitled to rely on that deferral, that arrears of rent under Section 8 on or after the 1st of November, say. Anything that you do agree on that basis should be in writing, should be agreed by both of you. It's fine to agree things in an email, especially in these quirky times, but make sure that it's clear that in writing and agreed. And if there's any doubt whatsoever, given that you're talking about what could be quite large sums of money, then do think about speaking to a landlord and tenant expert solicitor like myself or Vinay, and we'll be able to help you out with that. What about problems for landlords who are having a bit of difficulty paying? It was talked about a lot at the beginning of the lockdown period that various banks were going to sort of offer mortgage payment holidays. That was mostly focused on owner-occupiers and protecting people from mortgage repossessions on their homes. But a lot of banks have said that they're offering mortgage holidays for buy-to-let investors. It's up to 3 months, and if you can show, in a lot of cases it has to be that you can show that the tenants are struggling to pay their rent due to COVID-19 and the problems that have arisen therefrom. You will need to be up to date, and you need to be on top of your mortgage when you ask them about this, and you'll need to have everything else in place and then discuss it with your bank. We've put a list of some of the major lenders there who have said something specific about whether or not they're doing buy-to-let payment holidays. But the best thing to do in any case is always to speak directly to your bank and to the person that you deal with at that bank. Buy-to-let holidays, mortgage holidays are obviously something, they're not just a time off from paying. Interest will continue to accrue. It will extend the term of your mortgage. You'll end up paying more money, and it's not necessarily the best thing to do, even if your tenant is having bother paying, because of the additional time that it might add onto the mortgage and various. A lot of these problems, and mortgage holidays, I think in particular, are being and addressing these problems by kicking the problem a bit further down the road. Like, what if adding some extra time onto these mortgages causes problems in the future? I don't think that that's been really thought through just yet, but it would be a pause if necessary. So what are my responsibilities during lockdown? Well, as I said, in regards to the tenants' responsibilities, the fact that we're in a public health emergency, the fact that we're in lockdown, doesn't change anything about the contractual arrangement that you have with your tenants, and that contractual arrangement then has to be viewed through the prism of landlord and tenant law. So there are always responsibilities on landlords with regards to their properties, and there are, and those are not reduced, mitigated, removed, or otherwise messed around with by the lockdown in the coronavirus. I've gone through some of the sort of highlights here, but they're the normal obligations and responsibilities that are upon landlords to deal with their tenants and their properties. So keep your rented property safe and free from health hazards. Obviously, be aware of the Homes Fitness for Human Habitation Act that amended the Landlord and Tenant Act recently, which basically means that homes have to be fit for human habitation in a much more strict way now, and there are much stricter penalties available to tenants against landlords who are in breach of that. Always make sure gas and electrical equipment is always managed, and gas safety certificates, cannot emphasise it enough. Always stay on top of your gas safety certificates. Do not let them lapse. Do not miss them. Your tenant will become a secure tenant, and they'll live in the property for the rest of their life. Your responsibilities regarding energy performance and tenancy deposits and right to rent, how to rent, all of these ordinary obligations remain just as in place as they were when everything was hunky-dory back in the earlier part of the year. So, what about if you absolutely have to get new tenants? At the beginning of lockdown, nobody was allowed to move house. Well, that's not strictly true. People were allowed to move house if it was reasonably necessary, but estate agents weren't allowed to work, and people weren't really allowed to do house viewings, so nothing was going to happen. Since 13th of May, there's been more freedom to do things if reasonable. Tenants are allowed to view properties as long as it's done in a way which is corona secure, COVID secure, or whatever we are calling it. That means social distancing. That means making sure, the best thing to do, I think, is to make sure that people are not in the property when you're viewing it, because then there can be no cross-contamination. I dread to think what the legal proceedings might look like if somebody claimed that their estate agent was showing somebody around their home, and then that person infected them with coronavirus because the estate agent hadn't taken adequate precautions. And there's going to be quite the landslide of litigation, I think, in the coming years, as we deal with the fallout of this. But that's just me thinking of worst case scenarios. Obviously, you still have to comply with the usual rules. So that's, not breaching your tenant's quiet enjoyment of properties, not going in without permission. Accessing shared areas in HMOs is permitted, but otherwise don't go in without permission. And as with all of this, as I've said a couple of times, all of the usual contractual rules apply, and the contractual arrangements that applied before the lockdown, before this whole situation, are still in effect regarding the tenant's right to quiet enjoyment and access to their properties. So looking further ahead, and I know Vinay touched upon this about the potential repeal of Section 21 proceedings, it was a half-formed idea, I think, that somebody said in government in summer of last year. And what they were talking about was saying, do we really need no-fault evictions? As a concept, it's existed since 1988 in the Housing Act, and before that it was harder to evict people on that basis. I wasn't in practice then, so I don't remember. But they consulted on, is no-fault eviction under Section 21 still necessary? Is it still appropriate? Is it something which is, a good part of the housing market? Obviously, there are voices on the side of tenants who say, once I'm in a tenant property, I shouldn't be made to move until such time as, until I breach my tenancy or I want to move. There are people on the tenant side of it who say, like, that kind of security would create a really stagnant market, because it would be really difficult to get people moving on who are perhaps in the wrong place. And there are landlords who are saying it would make it extremely difficult to recover possession of my property. And it's a big argument. The consultation was finished in October 2019, and the government have since sat on it. So there's no indication, as far as I've heard, of when they might say what the report says. And it was discussed in Parliament on Monday afternoon, and the government was asked by the opposition whether the lockdown would be a good opportunity to look at this again and to say, look, while people are in lockdown and when people come out of lockdown, is no-fault eviction going to have a place in that letting landscape? And the government's response was to say, we'll get to it when we get to it. We're not going to bring it forward, and we're not going to change our plans. And they don't appear to have any plans on this at the moment. They're just sort of sitting on this report. So it's a big question. The other thing that I read this afternoon, which I therefore haven't had an opportunity yet to put into a slide, was about dealing with Section 8, and was about what is going to be the norm with Section 8 proceedings going forward, and especially after the lockdown, where people have been unable to pay the rent due to the coronavirus. Is that going to be a basis for an eviction? Because there's a part of the eviction process called Ground 8 or Section 8, where if a tenant is in a certain amount of arrears, which depends on the length of their tenancy, the court must make an order evicting them. So there's no discretion available to the court to say, I know it's 2 months arrears, but let's look at the context. It's just an automatic order. The Possession Working Group, I believe they were called, which is a group of judges and senior lawyers in this area, were looking at whether that would have to be perhaps watered down, but there was no indication of the conclusions that they came to. So it's a big fat don't know at the moment on that one. Therefore, apart from putting a delay on things, there is not much change in the practical processes on what's happening with regards to landlord and tenant law under the lockdown, and perhaps more importantly, once we come out of this lockdown period. So it's going to be interesting to see how it plays out when we get out. I think it's going to lead to a sort of tightening up of attitudes. But perhaps I'll hand back to Vinay, kind of talk about what the next steps are going to be.
Oh, thank you. Yes, so just following on from what Daniel has said, I mean, we anticipate that the government really have got their beeline down to the Section 21 and also tightening up on HMOs. We suspect that tenants, on balance, tenants' rights will increase. We suspect from what we're experiencing in the courts that judges are more likely to be or less sympathetic to landlords' arguments in terms of any technical fault and indeed any counterclaims. We're beginning to feel this sense that the balance has indeed changed and will continue to change against the landlord. So getting it right is important, but also mitigating your position is important as well, particularly in light of the potential new laws which may come in. So getting the tenant right and treating him or her correctly so that you have that tenant in situ for a very long time is a good thing. However, I've got to say one other thing, which is this tendency for tenants to believe that this could also be a golden ticket to a council house. And with the Section 21, there was always this opportunity for tenants to use with the Section 21 as well as the Section 8 potentially to effectively get an eviction order, take it along to their local authority and be catapulted on the housing list. And this was a tendency which we certainly saw through in the last 5 to 10 years. As council housing stock goes down, that's been less so, but it's still, the pressure is there. And unfortunately, that means that landlords are stuck with having to push through possession proceedings reluctantly when the tenant's agenda is something else. That's something to be wary about. How do you mitigate these situations? Obviously, insurance is one, and rent protection schemes, and there's a lot of it around. But beware, they're pretty expensive, and what you get out of it is not as much as you think. And there are particularly a lot of exclusion clauses, and you've got to read the policy very, very carefully. So I would always recommend something very, very cheap and extremely effective, and that is household insurance. And they have a tick box where do you want some legal cover? And being a solicitor, I always tick it. I think it's great. I think it's cost effective. It's pennies, and you get legal cover. And the sort of cover you get could cover things like possession action. So something to think about. But in the long run, I can see that lawyers will be very, very busy. I can see that judges are going to be less sympathetic to cases generally, and I think the courts are going to be clogged up. I think delays of up to 4 to 6 months, regardless of this new fandangle of having video conferencing, telephone hearings. We've done quite a few of these, but I don't really think the courts are up to it. So I would say get a good tenant and stick with them. Thank you.